welcome back to Legalese Translator. In today's video, we're going to talk about what's called default judgment. So when someone sues you and you ignore them and you don't defend, that person can get a judgment against you through what's called a default judgment. And so there are actually a few steps involved. And so what I'm going to ask Heather to do is to explain to us a little bit more about what's involved in a default judgment. So Heather?
Yes, thank you. So if you're a defendant and you are served with a statement of claim and you sit back and you say, oh, I'm not going to do anything, well, then the plaintiff can ask the court to note you in default. And if you've been noted in default, then that allows the plaintiff to then go to the court and get a judgment against you without a trial. And there's different ways to get a default judgment. One way is to have the registrar sign off on a judgment against the defendant. But you can only take that very simple method if your claim is for what we call liquidated damages. So liquidated damages would be your claim is about getting money repaid that has like a contract. So like there's a document that the court can just look at in your claim, or you're asking for foreclosure on a mortgage, but the amount payable, like the amount of money that is owed, is fixed by an agreement between the parties. But let's say you're asking for damages because someone hurt you, or you got bitten by a dog, or you slipped and fell. That you would have to go to the court before a judge, and you would have to have a judge give you a judgment. But its default judgment is special because we're not going through a whole trial. Instead, you're basically bringing a motion, and a motion would have the notice of motion, and it would have an affidavit. And the affidavit would set out the evidence to prove why you're owed that amount of money.
So you still have to justify your claim, right? You can't just, you're not just gonna go to court and then the registrar or the judge will say, oh yeah, sure, the other side's not defending, I'll just give it to you. It's not that automatic, is it?
No, usually you're going to want to have an affidavit for the court to look at.
All right, so let's switch it around now a little bit. Let's say that I am the defendant and I surprisingly found out that I got a default judgment against me, and I'm up in arms, I'm really mad, I never even knew I was being sued. Is there a way that I can go to court and say, hey, wait a second, what is this default judgment? I want to cancel it, like I want to reverse it. What do I do?
Exactly, yeah, there is something you can do.
Oh, okay.
You can bring a motion to the court to have the default judgment set aside. And in setting aside a default judgment, the court will look at different factors, like, were you actually served with the claim? Maybe you never got the claim.
Right.
Yeah, and they might look at how viable is your defense. So maybe you have a really strong defense. The court may consider that as a factor for setting aside the default judgment.
Okay, so that's great for clearing that up. So thank you very much for watching, and be sure to stay tuned to our video series. Don't forget to click subscribe, and we'll see you at our next video. Thank you. Bye-bye.
Bye.